In the late 1970s, a dispute between the White House and Congress on the limits of presidential authority created more than just the usual awkward tension in Washington, D.C. It also led to a badly fragmented United States Supreme Court decision in Goldwater v. Carter. Without the Senate's approval, President Jimmy Carter unilaterally rescinded a defense treaty with Taiwan. Carter was hoping to form a new treaty with the People's Republic of China. In so doing, however, he incurred the wrath of Senator Barry Goldwater and several other senators who filed a lawsuit against the president. The Constitution is silent on how a treaty can be terminated, but the senators argued that because a two-thirds majority in the Senate is required to ratify a treaty, the same Senate approval is also required to nullify a treaty. The district court agreed and held that congressional approval is required for the termination of a treaty. The Court of Appeals reversed, holding that unilaterally terminating the treaty was within the president's authority. The Supreme Court granted cert to determine whether the president can unilaterally terminate a treaty. Without oral argument, the court issued a two-sentence per curiam opinion holding that the question presented wasn't justiciable. The court remanded the case to the district court with instructions to dismiss. Given the opinion's brevity, several justices wrote separate concurrences and dissents to express their individual views. In one concurrence, Justice Rehnquist argued that the case should be dismissed because it presented a political question. Rehnquist focused his argument on the first two factors of the six-factor test previously announced in Baker v. Carr. First, is there a textually demonstrable constitutional commitment of the issue to a political branch? Second, is there a lack of judicially discoverable and manageable standards for resolving the issue? Regarding the first factor, Rehnquist noted that the Constitution expressly grants the Senate a role in the ratification of a treaty, but it's noticeably silent on how a treaty can be terminated. This means, Rehnquist argued, that the issue is left up to the legislative and executive branches, sometimes referred to as the political branches. For the second factor, Rehnquist argued that the absence of a constitutional provision on treaty termination indicates that this case must be resolved by the political process, not the judicial process. Lacking a clear constitutional standard for judicial resolution, Rehnquist argued that the issue was a non-justiciable political question. In another concurrence, Justice Powell supported dismissing the case on the ground that it wasn't ripe for judicial review. Powell argued that a dispute between Congress and the president isn't ready for judicial review until after each branch takes official action to assert its constitutional authority. While several senators filed a lawsuit against President Carter, there was still no official congressional action, such as a vote declaring the Senate's authority. Until Congress challenged the president with the appropriate formal action, Powell argued that the case wasn't ready for the court to consider. However, Powell disagreed with Rehnquist about whether the case presented a political question. For the first Baker factor, Powell reasoned that because no constitutional provision gives the president sole authority to terminate treaties, there's no textually demonstrable commitment of the issue to a political branch. This constitutional silence, Powell argued, called for a judicial answer. For the second Baker factor, Powell reasoned that the issue could be resolved by applying ordinary principles of constitutional interpretation. Justice Brennan dissented. Like Powell, he argued that there was no political question. This issue, Brennan argued, was a matter of ordinary constitutional law. The court merely needed to decide which branch had the power to nullify treaties. As a result, the matter fell squarely within the judiciary's domain. Therefore, Brennan went on to reach the merits of the constitutional issue. He observed that the president has the exclusive authority to recognize and withdraw recognition from foreign countries. In this case, the president's cancellation of the defense treaty with Taiwan was incident to his recognition of the People's Republic of China. It thus fell within his authority to conduct foreign policy. Goldwater v. Carter is one of the most fractured opinions in Supreme Court history. Although the justices' opinions illustrated different approaches to the justiciability doctrine, the case left a major question of constitutional law unanswered, namely, whether the president can terminate a treaty without congressional approval.